We're going to talk about the new Copyright Act and what that can mean for emerging businesses. I'm not sure how much people here know about the new Copyright Act. It came out in November of 2012, so it is in fact quite new. So I want to give you a little bit of background and things to think about. One, as you can see from the title of my talk, one of the things that has been pointed out about this new Copyright Act is it is very user-focused. So I want to look at the user-focused portions of it because, of course, everyone sitting in this audience who might be part of a business or an emerging business wears two hats when you look at the new Copyright Act, what you can do as an individual with copyright that falls into your hands, and then also the way that you want to use the copyright that is part of your business for your best advantage. So we're going to look at both ideas today. And the first thing I want to bring up is that there's often a misconception about copyright and other types of intellectual property rights in that people will often come to see me as a patent agent in particular or as a person who works in copyright and say, I have this great idea, and they've done nothing past the idea stage. Intellectual property rights in Canada do not protect pure ideas as they exist in your head. They need to have been what's known as codified. So these three circles sort of show the progression that we move through from the idea that it's just informal knowledge in your head, it's an idea, then you either write it down or you express it in a photograph or you express it in some kind of other written work or some other invention if you've created it. You put it into some kind of a tangible form, and at that point you have something which you might be able to get some type of intellectual property right to protect. That being said, there are many different types of intellectual property rights. And I know we're here to talk about copyright, but it's important, I think, to put all of these types of intellectual property rights into context so you can understand where copyright fits amongst these. One thing that I see a lot coming across my desk in a professional capacity are that people come and they say, I need to do IP due diligence because I have investors who want to look at what I have that's value in my company, and IP is a big value. And really what they list is all their patents, all their trademarks. And it's very, very vague as to what they might hold in terms of copyright. So I think it's important to put into context these different types of IP rights that exist and what the role of copyright is specifically. And one reason for doing that is that Canada in 2005 had a Supreme Court decision come down which was based on trademark law, but really makes a statement for all intellectual property rights in Canada. In this case, we had the owner of the Lego block, who had held a patent over the Lego block for many, many years, have their patent run out. So they no longer had patent rights. So they filed this as a trademark and tried to say, through this trademark, we're really showing the block, and in showing the block, we're showing its function, and therefore we can extend the right of protection over its function. And the court said, trademarks don't protect function, patents do, patent rights are ended. You cannot use a different type of intellectual property right to extend a previous type of intellectual property right you have that has ended. So in doing so, the court really said, intellectual property rights each play a role, and you need to recognize what that role is and allow for the right type of intellectual property right to give you the role, type of protection that you need. Not mixing them up, not trying to use a different type of right to give you the same protection that may have already run out for you. So that being said, let's take a look at what the intellectual property rights are, the main ones that exist in Canada. We won't go through all of them. And of course, the first one that comes to mind for everyone is patent rights. Patent rights give you the exclusive right, privilege, and liberty of making, constructing, and using an invention and selling it to others to be used. That's what you get with a patent right specifically. Registration is required. Registration is national. And if you are granted your patent right, you get the right for 20 years from the filing date. So that's what a patent is. It's specifically for an invention. Industrial design does not cover function, it covers aesthetics specifically. In the US, it's known as a design patent. In Canada, we call it industrial design. It gives you the exclusive right to make, import for the purpose of trade business, sell, rent or offer or expose for sale or rent any registered design or kit for design. It needs to be registered just like a patent does. The registration is national, so you need to register in each country where you want to have the right. And the right is 10 years from the registration date. So again, different than a patent. Trademarks. Trademarks are for words or designs or logos, that create a connection in the mind of a consumer between a product that bears that mark and the person or company who creates that product. So that's what they are specifically for. They give you the exclusive right of use of a mark, whether it be a word, a symbol, or a design, in conjunction with specific wares or services. Registration, again, is required. Registration is national, and you get right for 15 years from the registration date, and unlike other types of intellectual property rights, these are renewable. So then we move into the world of copyright. And again, copyright is not about pure ideas, it's about the expression of an idea. And copyright is different than its other intellectual property right cousins, as we'll see. Copyright can cover a whole bunch of different types of works. It can cover software code, manuals, the photo that's shown here, the written work that's shown here, CDs. It can cover the design that might be part of a trademark. But it's not a trademark, it just gives protection for the drawing portion of the design. So it gets a little bit confusing. It covers music, it covers film. And each of these are treated a little bit differently in the Act. And that's why it's important to recognize that copyright covers a bunch of different types of works, but it might do so slightly differently in accordance with the Act. So the Act breaks down categories of different types of works that it protects. Dramatic works, photographs, musical works, artistic works, literary works, sound recordings, performers' performances, and cinematographic, I can never pronounce it properly, but works in the area of film. And then it does cover some other ones as well. These are the main ones that generally get dealt with. There's broadcasting rights, communication, telecommunication, various other things that are dealt with by the Act. Again, if you're thinking in your head, what does my company own in all of these different areas? You have to recognize that when you're thinking about how you're going to deal with them, you then need to look at how does the Act deal with each of these and what actual type of protection do you have. So the first thing you ask is, do I have anything that falls within those categories? And the second question you ask yourself is, do I have copyright in any of those things that I own? So the test used to be, is it original? So if you wrote a book, you might have copyright in that book if it's original. If you took a photo, you might have copyright in that photo if it was original. The test got changed. In 2004, again, the Supreme Court spoke up and said, we're changing the test. The test is not just that it needs to be original, but that it also needs to be showing that there was an exercise of skill and judgment and intellectual effort in the creation of this work. So the best example I've ever heard of what this means potentially is, think of a 3-year-old who takes their fingers and dips them in the paint and creates a beautiful finger painting. The old test, it merely needed to be original. They may have had copyright in that work. The new test, you have to establish, does the child have skill and judgment, and did they put any kind of intellectual effort into what they've created? So the test, although similar, and in most cases we probably will be able to establish skill and judgment and intellectual effort, it is a step beyond the original test. And one of the reasons that this came into being is you look at something like a telephone book. Is there skill and judgment in putting together a telephone book or a list of some other type of information? So we moved into the world of databases where we're collecting information, merely collecting the information so that it's original information. That's not necessarily enough to have copyright over it. You have to show that there was some kind of skill and judgment in the way that that information was collected. So was it put in some kind of order that was specific, or took skill and judgment to put in place? To give you a little bit of sense of what these terms mean as well, skill means use of one's knowledge, developed aptitude, or practiced ability in producing a work. Judgment is the use of one's capacity for discernment or ability to form an opinion or evaluation by comparing different possible options in producing the work. And that it's not purely a mechanical exercise means that the exercise of skill and judgment required to produce the work must not be so trivial that it could be characterized as a purely mechanical exercise. So that goes to intellectual effort. It has to be beyond being a purely mechanical exercise. And again, what they were having trouble with at that time was people taking information and just putting it together in a list and saying, I have copyright over this list and no one can copy this list. Was that enough to actually give copyright? And the court said, no, there has to be skill and judgment in putting together the information. So these are your first two thoughts. Do I have something that fits within the Act as something that might have copyright? And then when I look at that particular item, work, product, whatever it may be, when I put this test to it, was there an exercise of skill and judgment in putting it together? If you can answer yes to both of those questions, then likely you have copyright. Now let's talk about the type of copyright you have. And before we get into exactly what right you have, let's look at the new Act and how it came into being. We had Bill C-60 first put out there in 2005. The government fell apart. That bill ended, died on the table. So new government comes into place. 3 years later, they come up with another bill. They put it out there. And again, we have the same problem. Government falls. We have a new government. We do this a few times until we get to the new Act, which was Bill C-11. It was identical to the bill previous to it, so they didn't have to make a lot of changes there, which was nice. It received royal assent on June 29th, 2012. Parts of it went into force on November 7th, 2012, so it's very new. And parts are still to come into force. So please be aware that not all of it is active as of yet. So when we first started off in 2005, one of the real questions out there was, how are we going to have balance in this Act, or are we going to have any balance at all? Because our real question out there was Napster. Napster allowed for the copying of music, and it allowed for peer-to-peer. Everybody was very upset, especially the music companies, saying, what on earth is going on? We're losing tons and tons of money by having this happen. It is obviously copyright infringement. We have to do something about it. Let's create a strong Act that slaps everybody on the hand who might be doing this. And if you remember, there were actually at least attempts to go out and to sue individuals for wrongful use of copyright and for infringement by using Napster and other types of products that allowed them to copy and to rip off music and to share it with their friends. So that's where we came from when we first started thinking about having a new Copyright Act. And where we've moved to since then is that we have a whole generation of people for which copying and sharing of various copyright materials is perfectly normal and part of their everyday activity. So when we were looking at what is balance going to look like in the Act when we first started this initiative, is very different than what we were thinking about balance in the Act by the time we got to the end of it in 2012. So we have an Act that looks exceedingly different, in my opinion, than what likely would have been passed had we passed a new Act in 2005. Our new Act is put into place, and the official reasons and justifications behind it are that it brings us into compliance with the World Intellectual Property Office treaties, which were passed originally in 1996, so we were a little bit behind the times in bringing ourselves up to snuff with our responsibilities under those treaties. It also creates a division between commercial and non-commercial acts, which is key, I think, in thinking, as I say, you're wearing two hats, thinking about what can you do as an individual with copyright that comes across your hands, as well as what, as a company, can you do with copyright, or how can you protect the copyright that you have? How far can you go? These are Government Canada quotes about what the new Act is supposed to do. It's supposed to legitimize activities that Canadians do every day. So stop making it a situation where the music company can come after the individuals, the way that was contemplated much earlier. And it's also supposed to, on the other hand, create certainty for innovative companies so that you can know what you can do to protect the copyright that you have in the best manner possible, and to make sure that your copyright is used legitimately and not infringed. So, what copyright protection do you get for your copyright materials? The copyright protection that you get, again, is different than the protection given to patents and the protection given to industrial design, so on and so forth. It is specifically the sole right to produce or reproduce a work to perform a work in public, to publish or rent a work, to prevent others from copying a work without your permission. It's very, very different than other types of intellectual property rights as well, because you do not have to register. There's no obligation to go to any intellectual property office and say, this is what I have. I need you to look at it. I need you to examine it. I need you to grant a right in it. As soon as I snap my camera and take a photo, I have copyright in that photo. It is mine. I did not have to get approval for it through any kind of overriding authority. I have it automatically. Also, as I travel around from country to country, most of the world are part of intellectual property right treaties that join us in our copyright protections, so that as I travel around with my photo, I take it to the United States, I still have copyright protection. So unlike the other types of intellectual property protection, like patents, where you file nationally and you only have rights in the countries where you file, same with trademarks. So if I file in Canada, I have a trademark in Canada. If I do not file in the US, I do not have trademark rights in the US. Copyright, completely different. As I travel around to the countries that are part of our treaties, which are most countries in the world, I still have protection for the copyright in my copyright protected works. Now, the thing to remember about that, though, is while I am here in Canada with my photo, I am under Canadian Copyright Act protection. As I go into the States, I'm under US copyright protection. These might be slightly different. UK, I'm under theirs. Again, slightly different, so it's not the exact same laws in all of the countries where you might find that you have copyright protection. Next slide gives you a little bit of an example about that. But the term of your copyright in Canada generally, it's different for some types of rights. As I said, there's those categories and they're treated just a little bit differently under our Act. But generally, it is the life of the author, so that's the person who originally created the copyright work, plus 50 years. So you have that person's, let's say I've copyrighted my photo, I live until November 12th of this year, I get to the end of that year plus 50 years. That's how it goes. So you get the year that the copyright owner passes away in, you get to the end of the year, and then the 50 years start ticking. You can also, in the case where it's not really an author who's going to create it, or it's various types of works that actually get published, sometimes the right starts from the first publication and then goes for 50 years. So this was with some of the works in the film area, with performances that are fixed in a sound recording, and with a communication signal. These all have rights that start from the first publication plus 50 years. Now, I've said that you don't have to file anything with a Copyright Office. You don't. But for those of you who have particularly valuable to your company types of copyright, you can file with the Canadian Copyright Office. And that can actually be a good idea. What it does is it establishes when your work came into being. It establishes who owns it specifically. And if you ever come down to the point where you need to go after somebody for infringing your work, you have a body who's recognized to be an official body, the Copyright Office of Canada, who can stand up and say, this filing was brought into our hands on this date, and therefore we can give you some kind of official notice that this was in existence as of this date. And therefore, when you are asserting your rights for someone who's infringing your copyright, you have that much more sort of authority or power standing behind your claim. So you can file if you want to, not absolutely required. So let's go back to the idea that not all countries have the same copyright provisions in their acts. I like this example because I think it lays it out quite well. In 1893, there was a song that was written by Patty Hill and Mildred Hill, who were sisters. It was known at the time as Good Morning to All, but it later became the tune that we know of as Happy Birthday. In 1912, there were lyrics first printed for Happy Birthday, as we know that song to be. 1935, there was a registration for copyright for the song Happy Birthday. And in 1946, Patty Hill died, and she was the second of the sisters to pass away. And that's important, that if you have co-authorship of copyright, the 50 years start ticking after the last of the owners to pass away. That's when that 50 years kicks in. So in Canada, we said that the copyright in that work died in 1996. Remember, ours is life of the author plus 50 years. In the UK, they say it will die in 2016. Their laws are life of the author plus 70 years. In the US, the copyright owner asserts, notice it's the owner saying this, that it will die in 2030. And the US has copyright laws that are also the life of the author plus 70 years, and this is a pretty good story. That's because of Mickey Mouse. Mickey Mouse was going to lose copyright. The US was very upset about this. They passed a law to give him 20 more years of copyright life. So they changed their laws from being life of the author plus 50 years to being life of the author plus 70. So Mickey got an extended period of copyright protection. But this just sort of lays out that even trying to figure out how long you have copyright may differ from country to country because there are slightly different copyright laws. Okay, so a really important thing you need to think about copyright that you hold is who is the owner of the copyright. And this is particularly important in businesses. Generally, it's going to be the first creator or author of the copyright. And that used to not be true for photographers, and that's why I've put down even photographers. Under the new act, that is true for photographers as well. And then you need to look at, was the work actually co-created? If there was more than one person working on that work to bring it into fruition, there is likely going to be joint ownership. So you need to make sure that you are recognizing that more than one person is the original owner. There is a section under our Act, which is generally called a work for hire provision, which sets out that if the person who created the work was actually an employee, or it could be an apprentice, then the employer will be the first owner. But do not be fooled into thinking you can stretch that into things like consultants. If you have a consultant working for you, the consultant will still likely be the first owner and first, because they are the creator of the copyright, they will likely still be the first owner. So this is important because you want to make sure that you can contractually tie up ownership of copyright. If you hire people to help you create various works, especially those that are going to be key to your business, you want to make sure that in the contract that you initially set up when that person comes to work for you, and you want to make sure you do set up a contract with them because quite often it's a verbal thing, but put something down in writing to make sure that you know that if that copyright is going to be important to you and you need to own it, that you do own it, that they do what's called assigning the rights to you. And in Canada, under the Canadian Copyright Act, an assignment is a means by which you transfer either the whole or a part of the rights in copyright. It has to be in writing and it has to be signed by the owner in order to be valid in Canada. And that again is important because we often find that people will come and they'll come and see me and they'll say, but you know, they told me that I would own it. That's not good enough in Canada, has to be written down. The other thing about copyright assignment is that if someone's coming to work for you and to create something for you, you can write into their contract that they're coming to work for you, this is how much you're paying them to do it, and as part of what they're giving you, they're going to give you the final product, but they're also assigning their rights to you. Then you don't have to pay them extra money for assigning the rights to you. If you do not do that up front and you need to get an assignment from them later, in Canada, of course, under contract law, you have to make an offer, there has to be an offer, there has to be acceptance, and then there also needs to be something called consideration. This is true for assignments as well. So if you do it after the fact, you need to give them consideration for the fact that they are selling you their rights in that copyrighted work, and therefore you would have to make another generally monetary extension of consideration to them. So if you do it all at once up front, much simpler and less expensive for you. The other way that you as a copyright owner can use your copyright is you can say, you know what, I don't want to give away my copyright, I'm going to license it to you so that you have a right to use it. You don't own it, but you have a right to use it. So that's another way, and often what happens is that you as businesses license in other people's copyright to be able to use for a while. So just be aware of the licenses that you have and the terms that are in them. And I bring this up in particular for open source copyright that may be included in anybody who works in software area. You may be using open source content in the software that you are creating. Open source, you are allowed to use it under generally what's called a general license, but there are various types of licenses out there. Be aware of what they say. Make sure you get copies of them if you're including anything that's open source in your software works, because some of them don't allow for commercial use of the code that's the open source code. So if you then use it in what you're creating, you use what you're creating for commercial use, you are in contravention of the license agreement that you had decided to sign. And what we often find is that it's an employee or a consultant who actually decides, oh, I'm going to use this open source. They don't really tell you about it necessarily. You find out afterwards, and it can cause problems because then you have to rewrite a whole bunch of code that you didn't realize was going to be problematic in the first place. So if you keep track of this up front, it's very, very helpful. You can file your assignments and you can file your license agreements with the Copyright Office. Again, it is a way of saying to the world, this is what I've done. Everybody knows that I've licensed this out to so-and-so. Everyone knows that I've transferred the rights and the copyright to so-and-so. And again, if you are taking on someone else's copyright, that can be helpful because, again, it gives you some kind of official support for that activity having happened and for your new ownership being valid. Okay, so let's talk about moral rights. Moral rights, again, are something that we look at when we talk about the fact that not all copyright in all countries is the same. In Canada, we have moral rights. The US does not have moral rights. France has stronger moral rights than we do, arguably. Some countries have them, some countries don't. They are key in Canada and something you want to deal with. What a moral right is it is a right in the integrity to the work. It is something that is owned by the creator as soon as they create the work. It does not get transferred with an assignment. The example that I like to give, because I think this sets it out the best, is Mr. Snow, who is the creator of the geese that fly through the Eaton Center. Everybody's seen the geese that fly through the Eaton Center, that big installation. The Eaton Center bought the geese from Mr. Snow and therefore bought the copyright from Mr. Snow and were the rightful holders of the copyright. Mr. Snow came Christmas shopping one year, looked up to see the geese flying away with huge red bows around their necks. And Mr. Snow, the creator of those geese, was appalled that anyone would do this to his very serious work. And he took the Eaton Center to court and sued them for infringement of moral rights because they had diminished the integrity that he had in his work. Moral rights were then again revisited, well, they've been revisited otherwise, but in 2002 the Supreme Court made this statement, which sort of goes to the fact that we haven't forgotten about the moral rights and we still hold them quite dear in terms of Canadian copyright rights that you are granted. They go to the extension of the artist's personality, they go to the dignity of the person who created the work, and if you prejudice the honor or the reputation of the holder of that moral right, you can be in trouble. The other thing that moral rights give the creator a right to is to always be associated with the work, so that if you are using a creator's who still has moral rights work, and you don't say this was created by, you could be infringing somebody's moral rights. Or, conversely, they have the right to say, I want to be anonymous. Our old act only had these for works, literary works, artistic works, various types of works. They didn't have them for other types of copyrightable materials. We have now had them extended to cover performers' performances. So this is actually quite a big thing because it extends moral rights quite a larger stretch than they used to sit previously. So this is something that you want to be aware of, and the only way to get rid of somebody's moral rights is for them to waive them. So again, when you're looking at contractually working with others who are creating various types of copyright protectable works for you, it is a good idea contractually up front to have that person waive their moral rights so they can't come back later after you are the owner of that copyright and say to you, the way you're using it, I don't like it, you're infringing my moral rights, and make life difficult for you. So if it is something that makes sense to do, it is easier to have them waive the moral rights up front in the contract that you create with them when they start to work for you. Okay, so now let's move into some of the types of ways that people can use your copyright that will not be considered to be infringement of your copyright. So we have something and have had it for quite some time in our act called fair dealing. So this means it is not an infringement of copyright to do the following. We always had it for research, private study. We now have it extended also for education, parody, and satire. So if somebody wants to use your copyrightable works for either of those three things, they're more than welcome to do so under the new Act, although they were not previously. We can also use copyright material for criticism or review without that being an infringement, and for news reporting. Then the Act, when we talk about it being user-friendly, also put in a bunch of other uses of copyright that will not be considered to be infringement, that will allow people, as being individuals, to act as they just normally act on a daily basis. So this includes a non-commercial user-generated content. This really goes to YouTube videos or to music mashups that are created from non-infringing sources. So if they got the music because it was copied by somebody who wasn't supposed to be copying it and gave it to them, this doesn't count. It has to come from non-infringing sources. But if a person decides for non-commercial purposes to create a YouTube video or a music mashup using other people's copyrighted works, it will not be considered to be infringement of those works under this Act. Move them into the commercial world, whole other story. If they want to create the YouTube video or the music mashup or various other combinations of copyrighted works, you will not fall under this provision. It's only if it's a non-commercial use of the copyright. People can use copyright of others for private purposes. So this gets us into the world of, I bought a CD. Obviously the copyright in the CD is held by the music company who sold me that CD, but I can actually make a copy of it onto my iPod. That's not considered to be an infringement of the copyright because I'm making it for my own personal use. I make a copy of it onto a CD and I give that to my sister, I've stepped into a whole other world because that's not personal use. So we're talking about personal use. You are allowed to do certain things with other people's copyright without it being an infringement. These are just trying to keep us in the world of things you do anyways, making sure that those don't become situations where you can be sued for doing small things. One that's, I think, a really good thing for businesses is backup copies. If you have licensed software from another company, you can make a backup copy. You can't share that with anyone. That would be stepping outside of this provision, but you can make a backup copy for yourself. Educational institutions, we've extended new rights to them under this Act. In particular, students who are studying at an official educational institution, they are allowed to make copies of the lessons that are given to them. They can only hold those copies until 30 days after they get their final evaluation, and then they have to get rid of those copies. But for the time where they're taking the course and 30 days after the final evaluation, it's okay for them to have had a copy made and to hold on to that copy. Again, they can't share it around. Also, just so you're aware, in case you have content that's being put out there online and you run into the case where you find out that some educational institution is making a copy of it and handing it out to their students or displaying it for use during lessons, that's okay now too. Again, somebody making a copy of that copy would not be okay. But as long as an educational institution, and this is official educational institutions, they're defined under the Act. It's not just someone who decides to set up a home educational system. These are secondary schools, primary schools, universities, colleges. They're allowed to take works that are available online and use them for teaching purposes. Libraries, archives, and museums. There was a case a few years ago about the whole idea that they have copy machines in the libraries and people make copies, and were the libraries and archives just facilitating copying, and was that wrong? And it has, the new Act has granted rights to libraries and archives and museums to be making copies for legitimate purposes. And I won't go into those in great detail though. Yes?
I noticed students in university, like, they literally copy everything, and including like textbook copies and so on.
Mm-hmm.
How do those fit in here?
They would fit in that if they're doing it for the purpose of a course.
Yeah, so instead of buying, they will just get a copy, right? Somehow, somewhere.
Oh,
they will just,
okay. Yeah.
Whether it be textbook material or some kind of, aid material that's actually, has copyright, but
Yeah.
in real life, they just have all
Yeah, so the purpose of some of these new provisions is to make it so that not all of those cases where students are copying will be an occasion to find that the student is infringement of copyright, but you need to read the Act in terms of what is allowed and what is not allowed. It's not just general students can make any copy of anything anytime they feel like. There are specific provisions in there now extending rights to students to make copies of certain things, such as lessons. If they want to go in and they have the permission of their instructor to do so, they can, for instance, make a tape recording of that lesson, and then they have to get rid of it after this 30-day period of allowance ends. So you need to, in terms of deciding what is allowable and what is not allowable for students, you need to look at the Act with a little bit more care and detail. So I won't go into that right now in front of everyone, but that's basically the quick answer to your question. No problem. Okay, so then we come into where commercial versus non-commercial really gets down to an important determination. There are different damages that you can seek from someone who has infringed copyright, whether they did it for commercial purposes or whether they did it for non-commercial purposes. This is new. It used to be if you infringed, there were damages. That was it. Now there are damages depending on the use that was made due to the infringement. Non-commercial infringement is capped now at $5,000. Commercial infringer, $20,000 is the cap per infringement. So if they copied 5 songs, $20,000 per song that was copied for commercial purposes. That's the way you read that. So it no longer makes sense for the idea of the music producers going after the individuals who copied a couple songs from each other, because they're going to be capped at $5,000 per song. But it makes a lot of sense to put your eyes on people who are using your copyrighted materials for commercial purposes, because you have a much higher amount of damages that you are likely to get if you seek out those individuals. One thing that I wanted to point out, which this isn't in the Act exactly, but in the readings that I've been doing, I think this is important. What is a commercial purpose? And we've run into this in other areas of intellectual property, such as patents. There is a provision for an exception for research, that you can use patented materials for research, and this has caused all kinds of confusion. Is that any research? Is that only commercial, non-commercial research? Does that include commercial research? What is commercial research? What is non-commercial research? So this division between what is commercial and what is non-commercial has created confusion in other areas of intellectual property, and likely, again, this is a new Act, just November 2012, likely will cause a little bit of confusion as we try and see this Act through and put it into place. So keep in mind that even though it looks like it's non-commercial, such as a free website, that doesn't mean it's non-commercial. So keep in mind when you're looking at things that you think it sort of past its face, what it looks like on its face, to are they actually selling something here? Are they promoting something on this website? Just because I can get into it for free doesn't mean I'm allowed to take things from it, or rip things out of it and share it with everyone, unless they have explicitly said so. So again. Mm-hmm.
If, for example, there is a commercial website
Mm-hmm.
for advertising,
Mm-hmm.
and someone copied this website and put on his website.
Mm-hmm.
For example, is it a violation?
If that person copied the website and put it on their own for commercial purposes because they now want to sell these products or appear to be selling these products, or they're selling products that are complementary to the product shown on the website that they copied, and so their intent of the use is commercial, then they will fall under the commercial infringer of up to $20,000 per infringement.
But the newspapers are copying all the time, like in other newspaper stories.
Yes, because they fall under fair dealing.
How about the links? Links.
If you are including,
Share, we make something else available to somebody else.
we're going to get to that. It's called enabling, and the quick answer is yes, that's going to be a problem.
What about derivative works? Someone uses your original concept and modifies it or decompiles it and makes something very similar, but not an exact copy.
In that case, you fall back on would they have a unique copyright in what they've put out there? Or are they really, is it so close that it's pretty obvious that it's just a copy of what you've done? In which case they don't have their own copyright, you had copyright in the original, and therefore they've infringed. So even if they've taken pieces of it and they've kind of mashed it up and put it in various other arrangements, if they've done so for a non-commercial purpose, they may fall under the right to use some content for a non-commercial purpose, and they might be okay. If they've done it for commercial purposes, they don't fall under that exception, and therefore you would have a right to at least say to them, like, look, you have blatantly taken chunks of my copyrighted work, and that is infringement. And again, this is going to be a little murky for a little while, this whole non-commercial commercial business. So you're going to have to keep your eye on the copyright world as it moves forward and tries to figure out exactly what this means. Now, the other thing I want to bring to your attention, because this is something that's been put in for the good of the companies. When we talked originally about the Government of Canada saying that it's going to give you more control over your copyrighted works, one way that it's talking about are through technological protection measures, which are otherwise known as digital locks. Breaking or circumvention is allowed for certain purposes, but otherwise it's an infringement. So if you break or you circumvent someone's digital lock for encryption research, for making computer programs inoperable, for investigation related to the enforcement of any act of Parliament for national security, for if that person who owned that work that actually has a digital lock on it, if they have not notified someone that they are using, that they're collecting personal information and that they're communicating personal information, that might be a reason to break or circumvent a digital lock. There are specific exceptions in the Act. These are not all of them, these are just some of them. To create a copy for someone with a perceptual disability, you may be able to break or circumvent a digital lock. But otherwise, if you have a digital lock restricting access to your copyrighted work and somebody breaks that, then they are in serious trouble under this new Act. And one of the things that they would be, how they would be in trouble is they would no longer be allowed to take this $100,000 to $5,000 cap statutory damages allowable for non-commercial use. That's out the window. If they break the lock even for non-commercial uses, they don't get this cap. So breaking a digital lock is quite a serious business under the new Act. Again, it's intended to improve the ability of the owner to control online uses of works. And the other thing to be aware of is that it is not an infringement in Canada to merely possess the tools or software that are capable of breaking or circumventing digital locks. Originally, that was what was proposed, is that not only would you be in trouble if you broke the lock, but you'd be in trouble if you had the tools in your possession to break a lock. They decided not to go that far in Canada. Yeah, so it's different than what it looked like. If you heard this being talked about when they first came out with various renditions of this Act, it did not end up being as strict as what they had originally said, but the whole purpose of this section is to allow you to be able to put measures in that protect your online content from other people getting at it, or not just online content, but content that you have that on some kind of medium that you might be able to put a digital lock on, be that a CD, be that a DVD, various other types of medium. The thing that I was thinking when I paused there about was the fact that you do need to be aware that some software on some computers has a breakage of a digital lock happening without you being aware of it. So you just want to keep your eye out for that, because we're not sure what they're going to do with that under this new Act. I don't think it was necessarily contemplated when they put this together. So it will be interesting to see what they do about that. Okay, so other things that they've put into the new Act to make life easier for some areas of business is it is not an infringement to be an internet service provider or to be a search engine. The reason that this may have been thought previously to be some kind of infringement is because technically you are copying other people's works onto a server, you're storing it for them, you're caching, you're hosting, you're doing all of these activities, which on their face and under the old Act appeared to be infringement. They've made it very clear under the new Act, not infringement. And then we get to the question that was asked earlier about enabling infringement. It is wrong still to enable infringement, and they have made it clear as to how that works in the digital world, that the ISPs and the search engines and people who engage in that type of business will not be allowed to do what they're doing. For instance, if they know that the content that they're holding is an infringement of copyright, they would be in trouble. If we go back into the example of Napster, yes, they didn't actually copy anything themselves. They allowed other people to copy, so technically they were not infringing. Under the new act, they will be infringing because they would be clearly enabling in the digital world. The other thing I want to add about that is that they've actually set out, I didn't put them down on the slide because it's a little long, but they've set out what the court is supposed to consider when trying to determine if enabling is happening. There are specific points that have to go into the thoughts of the court before they come to any kind of judgment on whether enablement is happening or not. So hopefully that will be helpful in guiding courts in making decisions. So the other thing that they've put into the Act is that a person who removes or alters any kind of rights management information is infringing copyright. This did not exist in the Act before. Rights management information is that's attached or embedded in a copy of work. It may have to do with the, it might identify or permit the identification of the work of their author, or that this work is the performance of a particular performer or the maker of a sound recording. It is information that is in there. It's part of your work. It's embedded in it. You can't take it out or alter it. You have to leave that in the work. So they are not only capturing those who take it out because they know that they're not supposed to and they do that, but if you should have known that taking it out was a bad decision, you will still be captured under this portion of the Act, and it comes under the same remedies as are available for infringement. So if you are found taking out rights management information, you will fall under the same idea that you might be up to $20,000 per wrong. Okay. And the last thing to keep in mind is that, of course, the Act is not entirely enforced yet. And the one provision that is not enforced yet are notice and notice provisions. And what these are is that if you notice that someone is infringing your copyright, and it's online copyright that is provided through an internet service provider, you can go to that internet service provider and give them notice, and they will then have to act. And that's why it's not enforced yet, because we're not entirely sure what that's going to look like. In other states and other countries, they have had notice and takedown, so that if you give notice to the ISP has to take it down. Or they've done notice and termination, so if you give notice to the ISP has to terminate that infringer's account. We've not done that in Canada. We know that's not where we're going. We're going to notice to the ISP and then notice to the infringer, but we're not sure where we're going past that and exactly what that's going to look like. So keep your eyes out for still more changes to the Copyright Act that are going to happen. So basically the message through all of this, from all of what we've looked at, the role of copyright in Canada versus other intellectual property rights, the new Act and the new provisions that have been put out there and what that means for a user having a little bit more freedom to do some things, but also some provisions that have been put in place for companies to have stronger protections for their, at least for their online content that's copyright protected, absolutely. Things that you should think about as companies is you need to recognize what individuals can do for copyright in terms of non-commercial versus what can be done by those who fall into the commercial world of uses of copyright, and recognize that there is a division there, and so that might help you decide where you want to put your focus in terms of stopping infringement of your works. You want to recognize what you are allowed to do as those who are acting in the commercial world. So again, when in the world of digital locks, there are, although the overriding rule is don't break or circumvent a digital lock, there are some things you can do. You can break it for encryption research. You can break it for various reasons. So it's not that your hands are tied entirely. Keep in mind what you might need to break it for, and figure out, is it okay for you to do so. recognize the aspects of the Act that allow for better control of copyright, because the Act is user-focused, heavily user-focused. That is absolutely true. But there is an attempt in there, a stated attempt by the Government of Canada to also allow the Act to provide greater and more authoritative protection for your copyrighted works, especially in medias that were not contemplated, such as the digital medias, when the original Act came into place. So keep that in mind. And also really think about implementing measures and contractual terms that will let you shape the ownership and the protection of the copyright that you really need. So again, if you're bringing people on to work for you, think up front about what you need to put in your contracts with them that will help protect the copyright ownership that you might need, or licensing that you might need. And then also think about, I'm going to put my copyright in this kind of a media. How can I best protect it? And do I need to? Like, am I wanting to share this, or am I wanting to protect this really stringently? So how am I going to act, therefore, in accordance with what's in the Act and what my intentions are? So I hope that gives you guys some things to think about in terms of the new Act. I'm happy to take any questions you may have.
Using copyrighted material, like research analysts reports from Gartner or Forrester, if I want to reuse some of the material, as long as they're sourced on my online content, that's okay?
You're using them for what purpose?
For a white paper or a research report that may be using some of their ideas.
If you're using it for a non-commercial research report, then you'd be fine, just to make sure that you're admitting where it came from and who was the original creator of it.
Okay.
Yeah.
If a not-for-profit organization develops some kind of educational resource that they want to put into the schools, and they use copyrighted material in the resource, and they don't have permission, is that an issue?
It could be an issue. Again, because the Act has all of its different sections, they don't necessarily, and again, when we look at commercial versus non-commercial, we're not really sure where not-for-profit is going to fall. So you'd probably want to look at that in a little bit more detail as to whether that's okay or not okay. And also looking at it in line with the new provisions that are out there for what educational institutions are allowed to do in and of themselves. There are some provisions saying if you are going to if you're going to teach for an educational institution, but you are not an educational institution yourself, you still have some exceptions and some rights that are granted to you under the new Copyright Act. So you'd want to take a look at exactly what those are and where you're going to fall.
I know it's a little bit more broad question, but if in 2 words, what's the status of the business method patents in Canada right now? Methods of
for patents?
Yeah.
For methods of doing business?
That's right.
As a pure method of doing business, they're not purely allowable in Canada. If they have aspects to them that bring them out of being a pure business method and into other areas that are considered to be patentable subject matter, then you would want to really highlight those in your patent.
But as far as I know, this since beginning of last year, 2012, they were on an example of the Amazon's one-click.
Yes.
Finally allowed in Canada.
Yes, not as a pure business method patent though.
Yeah.
Under other criteria it was allowed. So we have not changed our law in saying that we are opening our arms to business method patents. And on a little topic that sort of goes along with that, the US is closing their doors. So Canada is not opening its doors while US closes it. Both are kind of coming in at a medium area of you need to have something else going on.
The US is closing in terms of, so they are just narrowing the definition? Or?
Well, I think you and I might have a chat about this offline just because it's off topic of copyright. But if you want to chat about that later, we could. Yeah.
What about advertising materials and things like that? Are you obligated to put the little C and first use date on there? Or what about material that doesn't indicate any type of copyright?
Well, then it falls into one of your business decisions. So is this something, is an advertising material something that you want to have some kind of strong protection for? Putting the C on it and putting the date, under some jurisdictions that's absolutely necessary. Under other jurisdictions it's not necessarily necessary. In Canada you can do it if you want, it's recognized, but you don't absolutely have to necessarily. If you do put it on there, you're definitely putting people on notice that this is you consider this to be material that you own that is copyrighted, and that as of this date it was copyrighted and people should stay away and not copy it. So it really comes down to a business decision as to whether this is something that you want to put the world on alert that you are protecting as copyrighted or not.
Do you change the date on new releases all the time, or the first date of issue is adequate?
Well, really what you're putting people on notice for is as of this date, this existed as copyright. So if what you're putting out there, the whole of what you're putting out there as a copyrighted work was not actually in existence as of, let's say you put 2010 on it, if it didn't all exist as of 2010, then you're misrepresenting the copyright date. So you should probably put either 2010 and then put a comma and say other portions as of 2012 or whatever the new date is, but you want to be honest about what you're saying the copyright date is for what you're putting out there. Yeah. Any other questions?
Is enforcement only available through the civil courts?
You know what? That is a very good question. And I have not looked that deeply into what they have done in terms of changing any provisions for the courts in the new act. So I'm going to refrain from answering that question on the basis that I'm not entirely sure. As far as I understand it, it's not a big change from the old act in terms of your options for where you can go and get some kind of justice, shall we say, for a wrong that's against you for copyright. But I'm not sure about that wholly, whether they've made changes or not.
Is there any requirement for, say, a cease and desist letter first before one goes to enforcement?
Well, the nice thing about a cease and desist letter is that it puts somebody on notice so that they have an opportunity to mitigate the damages first. So it can go to your favor if you take that step before going straight to trying to get damages from them in a court context, because you may be able to come to some agreement and avert having to do that altogether. So it keeps the court costs down if you don't have to go that way, so it can be held in your favor if you try that as a first step.
Do the provisions of digital locks have primacy over provisions on fair dealing?
Sorry?
Does the provision on breaking digital locks have primacy over provisions on fair dealing?
Pretty much, because the digital locks, that would be a way to look at it. The digital lock section is very clear about what it allows you to do in terms of rightful breakage or circumvention. So anything that is not a rightful breakage or circumvention is a wrong, and likely that would go for any kind of exception. It definitely goes for user-generated content exceptions. So it would probably go to fair dealing as well. But hasn't been tried yet, so who knows where a court would fall on that. Any other questions? Well, thank you very much. It's been a real pleasure to speak with you, and I hope that you've learned something helpful and useful. And if you have any follow-up questions, just definitely let me know. But thank you very much.